What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Sunday. Happy Sunday. Hopefully you guys had a great weekend. You want to watch some court? I want to watch some court. Let's watch some court. All right. I don't really know what I'm playing tonight. It's Sunday, so we get a little bit of weekend review on Sundays, right? So the first one, I do know what I'm playing. I don't know why I say I don't know. Sometimes I forget the order, but I remember the clips at least. The first one, I kind of teased it. I don't know, a week and a half ago when it happened, and then I completely forgot about it until today when I was going through my live folder. So I separate my clips so from normal uploads to live streams. So I have a folder to put things in to make it easier to when I'm looking for videos to play. And it's like, what is this one? I don't even remember this one. I started playing and yeah, I completely forgot about this guy. So you're gonna like it. This is the guy who we can just call him Muse. This is a PPO case where the lady that fought a PPO on him, he thought she was his muse. Part one happened, I don't know, a year and a half ago. Well, they're back in court. Well, I don't know, a week ago. But I teased it on a live stream because I was gonna put it in a video and then I completely forgot about it. Second one's interesting. We've got a lady who got busted giving happy endings at a massage parlor. Yeah, she's in jail. And then the last one I you know what? I'm actually going to tell you. I don't remember why I put the last one in. It's Judge Carmi. You know what? That's all I'm going to say. It's Judge Carmi. Uncle Dan. Uncle Dan, off the bat. Thank you so much, Uncle Dan. You missed the super chat. I did. I always miss super chats, especially Dan's. Always. 100% of the time, I miss it. Never? I messed that up. It's Sunday. Forgive me. But thank you, Dan. And again, you missed another. Dan's having a good night. I think Dan had a good weekend. Good to see Dan in a good mood. I mean, it's not like we ever see him in a bad mood, but he's dropping super chats left and right. He must be in a really good mood tonight. That's good news for me. Anyways, you guys are awesome. Let's just get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right. I'm going to start at the top of my calendar with Rachel Berglund and Simon Ionescu. There we go. All right. Now this is going to serve.
That is awesome. I haven't been there since I was, 21. Yeah, that is a gorgeous area. I'm jealous. I really am. Heather's going to be here in about 3 weeks. Maybe I'll take her there. Yeah. Thanks, Alex.
Essentially as a guide for the rest of you as well. What we're going to do is I'm going to swear both sides in. I'm going to take testimony. And after I'll start with the petitioner, I'll hear from the respondent. I will give the petitioner one last chance to wrap everything up. There are, looks like exhibits. Let me know what's important about these exhibits in your testimony, all right? Okay, would both of you or each of you raise your right hand, please? Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes, we're
All right, thank you. You can put your hands down. All right, and one thing I didn't say, but need to make absolutely clear, we only have a few hours this morning for these. Testimony doesn't get to go on for ever and ever. Try to and it's not always possible, but try to make it brief but on point. You should anticipate, even though I've reviewed records, you should anticipate that I haven't looked at anything. I need to hear what's important, what happened from you, because you're here. Okay.
All right, before we get into this case, I know a lot of you have probably seen this, but not everyone has. I don't mind comments like this. That's fine. But let's keep spoilers to a minimum, please, please. I appreciate it. Thank you.
Rachel Berglund, you will start. What is it that this is a motion to renew a protection order. What would you like me to know here?
Oh, that is hilarious. I just assumed that comment meant you did. That is hilarious. That was a great point, though. It really was. So I assumed you did. That's awesome. Yeah.
Honor, for context, the respondent had previously to this current protection order had been stalking and harassing me for about 8 years or so, including following me when I moved to different states, then sending me random items in the mail, clearly indicating that he knows where I live, sending emails after I had asked him to not message me ever again or contact me in any way, shape, or form, proceeded to send over 100 emails full of inappropriate, just paragraphs of like super graphic, inappropriate stuff, including images that were AI generated of me being naked, and other pictures of himself. Probably there was a lot that I didn't look at because it was so disturbing and disgusting. So despite me asking to stop contact, there was like considerable harassment, causing me to fear for my safety on a regular basis. Since then, there was the protection order that was granted last year, and the judge last year said that this is the type of behavior that results in like worse things happening, that I should like, what did he say? He said that the respondents should get help and that this is a serious threat, and that he feared for my safety even, which was really validating because doing this whole process is like really scary and really stressful. So I appreciated that the judge could clearly see that there was something wrong with how I've been treated by the respondent. Since then, when the protection order was granted, or last year when he was emailed the request to show up to court, even though he had already received it and seen it, still proceeded to send me another email, like further contacting me, even though he had received notice that he was to not contact me and come to court. So hence violating the temporary protection order that he was given. And I've also received like strange things in the mail. And so I have no way to prove that that was him, but that was something that he had done before. And to me, it feels like if someone finds ways to like make me question my safety, even though there's a piece of paper that's supposed to protect me, but I can't prove, it causes a lot of anxiety and fear on a regular basis. I would really appreciate if this protection order could be renewed, because I don't think that if it were to go away, that the harassment would just stop. I think that it would either amp up or absolutely continue. If it happened for 8 years, it's not just going to go away.
All right, thank you. Mr. Ionescu, did I say that correctly?
Yeah, it's pretty close. Ionescu.
Pretty. Ionescu.
Yeah, it's a weird last name.
Okay. Well, I try to get it right. All right.
Okay.
You are the respondent. This is your turn. What would you like me to know?
Yeah. So first of all, I just want to point out I have maintained no contact. I've not violated the order in any way, and that's because I have moved on. And there's no need for renewal because there's no threat. There was actually never a threat to begin with. I mean, there was. I communicated and I over communicated with Ms. Berglund for a long time. Of course, all she heard is, "Oh, he's a psycho." Yeah, look, I could sit here and I could, huff and puff about the exaggerated claims and like the false narratives that she constructed in her report. like they did. I moved to states to be closer to her. I moved to California because my two best friends moved to Silicon Valley, and I was wanting to do a startup. I was working for a startup. Like I didn't move there for her. Okay, like that's absurd. So I mean, she's just exaggerating and making all these claims, but at the same time, I do understand why she is, exaggerating everything that happened between us because I scared her. Okay, I did, and I have to own up to that. I mean, last year I tried to apologize, and the judge said I was trying to maintain a relationship with her. I just wanted to say, oh, sorry, but whatever. So look, I will absolutely leave her alone. To be honest with you, look, there was actually some substance abuse involved in some of the emails that I sent her. And the only reason I was sending her all these emails was just because, for whatever reason, Your Honor, whatever reason, interacting with her improved my creativity. She has inspired an idea that I think has the potential to have a big impact on the world. And I just, I communicated and over communicated with her on all these things. And I think, honestly, on some level, I'm almost glad it happened because it led me to, well, things got much worse before they got better, especially after the video from last year. This trial went viral, and I started getting like all of my social medias were just attacked on the internet. I was attacked as people were in my comments, and I had to turn all my social medias private. And I think some of those were probably coming from people in her camp. I don't know, she probably.
All right. I say this a lot, but I know we get to see their names. I try to block out as much personal information as I can, but they're not hard to look up. Let's not do that. Let's not do that. You see this guy online, whatever. Let's not search him up though. We don't need to be that group, right? Right? Please.
I don't know who she told.
Oh, that being said, though, I completely believe it happened. This guy's a creep, and his video didn't go viral. Yeah, it was a entertaining video, so a lot of people saw it, but viral, no.
Or whatever. I mean, she's been in the military, and I suspect she got her group of friends to send me threats. I got all kind of threatening emails and everything else. So
Just on topic, please.
So my point is, like, that alone is like a big deterrent, but also we are 2,000 miles apart. Like, I live in Tennessee, she lives in Washington State. Like, the distance alone is a natural barrier. And like, look, I would never do anything to harm her. Like, the only reason that I was sending her emails is because I thought she liked it. Okay, I thought she liked it. And a very important point that I want to make here, and this is absolutely critical, is that yes, technically she told me to stop. Okay, I sent her about 115 emails in total. Around email 63, she told me to stop. Okay, and I didn't stop, and I should have. Okay, I acknowledge that. But the reason I didn't stop was because I was sending her money. Okay, and if you look at the exhibits, you can see royalties to Miss Berglund. You can see Venmo payments that I sent her at the time. She didn't say anything for over a year and 3 months. She said nothing to me. Okay, she was just quietly accepting the money, and that's where I think that plays a really critical factor in this whole misunderstanding. Is, I thought, well, she's accepting the money, and then she was kind of posting She unblocked me after that. I sent her money. She unblocked me on social media and started posting pictures, almost like she was cooperating, like she was okay with it.
Did I
And
hear you say
that's the
those were
thing.
royalty payments?
Yeah, I called her my muse. I said she inspired my work. I thought she was into it. I didn't realize, you know, it was causing so much fear and anxiety. I don't want her to fear for anything. That wasn't my intention. I thought, you know, we were friends. We were neighbors years ago. We got along. We hung out like all the time. We used to go boating together and everything else. I thought she was like, but you know, look, it doesn't matter. I've moved on. I will never contact her again. There's no need for a renewal. This is impacting my personal and professional life. You know, people are really questioning my character for over a misunderstanding. You know, I just
All right.
this is too
Is
much.
there anything else you would like me to know?
Yeah, well, I mean, okay. So one thing I will say is, I did when I reached my like low point. I went into counseling, and I didn't realize. I thought like my only problem was ADHD, and turns out I might be like she seems to accuse me of like being like a. She seems to think that I'm like a narcissist or like a psychopath or something. Um, but this is like a very common category error for uh, certain symptoms overlap. Turns out, I guess I'm slightly a little bit autistic, a little bit somewhere on the spectrum, and I think that probably played into my ability not to fully like. How do I say this? I have a hard time kind of um, picking up on social cues, I guess sometimes, and I think I totally screwed up. I did not mean to scare her, Your Honor. I did not. Like I actually thought she liked it. I really did. I thought she liked it. I thought she was into it, and I misread the entire situation. And this is just a big misunderstanding. That's all I want to say. Like, yeah.
All right. Thank you. Ms. Berglund. And you don't have to say anything, but if there is anything you want to say to wrap it up, it's your turn again.
You know what? I'm not going to say anything, Your Honor, because yeah, he just guaranteed I got the extension. Now he pretty much said everything he said during the hearing a year ago, and I remember I told you guys I would try to find it. I remember looking for it, but I couldn't remember what I named it. I couldn't find it quickly enough, and I think that's why I completely forgot about this video. I was like, oh, I just put it off, and yeah. So, anyways, we did cover part one, like I said, about a year ago, and he said about the exact same thing. But the first video, he used the argument of he sent her money a lot more. Like, oh, I was sending her money and she was accepting it, so that means we're friends, right? Yeah, it doesn't work that way. Yeah, just because you're sending money doesn't mean you're friends. Also, when she said stop emailing her, doesn't mean you send 60 more emails. That means you stop. I think most people know that, right?
Your Honor, I don't think there's really much for me to say other than that me saying do not contact me in any way, shape, or form. If I am contacted, I will be considering it harassment is pretty clear and not that easy to misunderstand. And I believe in your ability to judge the situation, Your Honor.
All right. Thank you. Okay. I am going to reissue this order. And it'll be just a moment while I fill out the paperwork. If, as you indicate, Mr. Ionescu, you do not wish to be contacting her, then this should be a simple year where you just don't have any contact. That makes it really simple.
Yeah. I mean, at this point, the damage is done. You know, if it makes her feel safer, that's fine.
Okay, since both of you were present, neither of you, I have signed that order for 1 year. Neither of you needs a copy, but both of you can get copies from the court if you would like. The order is renewed. That will be it for this morning. Thank you.
Thank you, Your Honor.
Yeah, that guy's creepy. That guy's creepy. I mean, he didn't need to say 99% of that story. He could have said, you know what, I didn't send her anything. That surprises me. That's all I won't contact her again, Judge. I don't need this. I don't need a protection order. I went a year without contacting her. I moved on. That's all he had to say. He could have finished his argument in 5 seconds. Instead, he went on for 5 minutes, and that was 4 minutes and 58 seconds, way too long. All right, we're going to move on to the happy endings case. Yeah, Judge Rossi. This, I'm not going to say anything. Let's go.
Of the people of the state of Michigan versus Edith Corbett, case number 24-04823-FH, and this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court this morning on Ms. Corbett's motion to withdraw her plea or for judicial vacatur of the guilty plea. At this time, I would invite counsel to place your appearances on the record.
Blair Lockman for the people, Your Honor.
Thank you. And Ms. Dagger-Margosin, you are muted.
I'm sorry. I'm Janice Dagger-Margosian for Ms. Corbett.
Thank you, ma'am. And this is your motion. I did read through it, and it appears that the primary basis here is that the factual basis that was elicited during the plea hearing itself did not meet the elements of the charge that Ms. Corbett has, pled to and is serving her time on right now. And that specific statute is accepting the earnings of a prostitute, MCL 750.457. And I did read through your brief and the prosecutor's response, and I guess my view of this, particularly in light of the appellate cases that set a somewhat relaxed standard for a judge accepting a factual basis, is.
Oh my gosh, Charles J. I thought the same thing because I've heard judges say that name many times, and I always thought it was a male. So I was like, oh, maybe I'm misremembering it. But now that you're saying it, maybe they got married and they just hyphenated their names together. I mean, maybe that's what happened. I have no idea, but I thought the same thing. Real quick. None of your business. Thank you so much. That is very generous of you. Welcome to the 20 new members. None of your business. Very generous. Very generous. Welcome to the family, the 20 new members. We'll see you tomorrow night for Members Monday. Also, Phil, generous of you as well. 5 new members, 25 new members, all at one time. That is awesome. You too. Thank you so much, Phil. None of your business. Thank you.
I certainly viewed, the entirety of the transaction that Ms. Corbett was involved in with these customers coming to the massage parlor as a transactional situation where the customer comes in, they pay Ms. Corbett the $50, allegedly for the room, but, let's be honest, under the facts of the case, it is for access to a room with a young woman who's going to perform a sexual act, and everyone has knowledge of that, and then, she accepts that money. It seems like a stretch to say that's not the earnings or proceeds of prostitution.
Can I respond, Judge?
You may.
Thank you. Well, number one, Judge, I think it's really important here. In light of, and I think the Maury case is really important, that you really do have to look at the language of the statute. Here, Ms. Corbett did not stand there and accept these door fees. So number one, I think the important fact is they were door fees. They were not money obtained from a sex act that was performed. And she was not present at the premises at the time she collected these fees. She collected them at a later time, at a different time, when these sex acts were not going on.
Well, let me just pause you. She wasn't the landlord of these premises. That was someone else. She leased the premises, and this was her business, right? Whether she was present for every moment. And certainly, I think everyone agreed, well, she's not present in the room when the sex act occurs, but that rather it was a scenario where she knew and allegedly, perhaps, to some degree, trained or, prepared these women for, the nature of this illicit massage business. Right. And further, I don't think that, the statute doesn't say you got to be standing there and the prostitute commits the act of prostitution while you watch it and then hands you a portion or some of the money. It just says that the person themselves knows what's happening, and then they accept, receive, levy, or appropriates any money or valuable thing, from that act. And I guess the other piece of that is without any consideration given to the person, presumably I'm trying to figure out what in the heck the statute means by consideration here. And the only sense I can make of it is, you're not giving any consideration back to the person who performs the act, but rather you're just taking the money or a portion of the money that comes results from the act in a broad sense, the proceeds or earnings. So, I guess, and that's really my thought in looking at the statute entirely is you'd like me to, impose a sequential order that this has to happen in time. And the statutory language to me reads much more broadly than that. It says, hey, if you get your hands on some of this money and you know where it's coming from, you're liable, that's what imposes jeopardy under the act. Am I reading it too broadly?
I think so, Judge. Respectfully, I think that, and this is what happened in the Morey case, is the Supreme Court looked really, really closely at the words of this statute. I think here you would have to have a situation where Ms. Corbett was receiving money from the prostitutes and knowing at the time she received it that that's what it was from particular sexual acts. Here we don't have that. We have a very generalized set of door fees. So I think what the area we're treading into is what
Morey
the
was a little
prosecutors.
different though, because it was the person was more or less who at least, and I didn't read, I just read your summary of Morey, but it sounded like that was a scenario where the person was receiving the calls and then directing the customers to a location to meet with a prostitute. And if there was any money changing hands, it would have been, a separate transaction or not, and in that, is that the kind of the background of Morey?
I think, and I summarized Morey as well as I could for you in the brief, but I think the important part of Morey and what happened at the Michigan Supreme Court level is that court said every single word of that statute has to be observed and complied with by the courts. And we can't, this is the kind of case where you could make inferences upon inferences upon inferences, which the prosecutor relies on in the brief, talking about inferences. But number one, this is a plea, so you got a due process concern of making sure, because you're not having a trial, you're not having a jury find these facts, that the defendant is establishing this guilt. And number two, where the inference upon inference, the old rule of Attlee, I believe it was loosened up in a case called Hardin in 2002, which still said you must have findings that are based upon evidence. You can't speculate. And in this particular case, we're in the realm of speculation. There were door fees collected. Ms. Corbett was not there to collect those fees. She didn't know what was happening in those rooms. There may be times certain things didn't happen. You don't have a transaction where a prostitute goes into a room, does an act, comes out, and turns over her profits. And I think that's, this statute, I think, derived from the times when there were, where
Brothel
prostitution was developing.
Right.
And so you had pimps that were taking fees one-on-one. You don't have that in this case. You have a very generalized setting that she made available. She didn't know what was happening in those rooms. The statute says.
Whoa. Is pimp a legal term? I thought that was a slang word. I mean, yeah, I don't know why that just kind of blew my mind a little bit.
Knowingly, that the acts must be profited from knowingly. She didn't do that. She provided a premises. It was known that in general this happened, but she didn't have a one-for-one knowledge that the money she accepted was happening. I don't think that there can be a reasonable inference here. I think you've got inference upon inference upon inference, and I don't think that has any place in plea proceedings, Judge. That's a violation of due process. So that's the summary of my argument.
Well, her own attorney asked her, and I'm on page 9 here of the plea colloquy. Mr. Fabian, you're aware that at least one or more of these independent contractors would perform sexual acts during the massage and in exchange for money.
Correct.
Ms. Corbett, yes, sir. I mean, how is that not acknowledging that she knows what's happening in those rooms, whether she's on the premises at the moment or not?
Well, but I think that, again, what we've got here is a generalized situation. So she is stating that she knows generally this happens. So that would certainly, we would agree, supports having a house of prostitution. She knew this happened, but she wasn't taking earnings as they occurred. She took a very general door fee. The women that did this work got some kind of tip. We don't know how much was tip. We don't know how much was door fee. This was not played.
Yeah, you never know how big the tip is until the process started, right? You know what I mean? Ha. Too soon? Not appropriate? Oh well.
Based on the record. And so I think that where you have to have some kind of specificity with a plea that complies with the statute, we don't have the knowingly element, and we don't have the transactional element. I think those things are clearly missing here.
Okay. All right. No, I think I understand the argument. Let me see if Mr. Lockman has any response in addition to the brief file.
I would just note, under that theory, we would never be able to do this charge, because they should argue that they have to know specifically that every dollar that comes in is for this, and that's not what the statute contemplates. I think the court hit the nail on the head. It's right in the brief. She acknowledged that these were independent contracts performing sexual acts during the massage in exchange for money. I don't know how you get more specific than that, and I don't think the courts require more specificity than that. And then she admitted that she collected a fee from every customer that entered there for, in quotes, massage service, which she was aware in many cases were for performance of sexual acts. I think this is, I think it's someone who, after sentencing, has decided they didn't like their sentence and is now looking for a way out and finding this defect. This is not a defect. This is a very clear factual basis that she knew what she was doing, and accepted that fact when she took that plea, and now she's just having buyer's remorse.
Okay. All right. Thank you.
Your Honor, if I could just place on the record, I appreciate that. I hear that from prosecutors pretty often. We don't have any evidence that this is buyer's remorse. What this is someone who had the right to have an attorney overlook her case and view it and see if there are possible issues that were overlooked at the trial level. I don't think disparaging my client is appropriate here. So just want to address that.
Oh, no, I understand. And of course, my entire job is to make sure that, each person that comes in front of me gets the full range of procedure they're entitled to. And a hearing like this is just that. So I don't attribute any of it to, some sort of ill intent on on behalf of your client. I know, and I know that you're simply doing your job here as well, and going over the proceedings, as it needs to be done with a magnifying glass to make sure that I get it right, because heaven knows. I was just thinking the other day, when I elected, one of the promises I never made was that I would be 100% perfect judge. I just said I was going to, fulfill the oath to the best of my abilities when I'm on the bench. And I appreciate the ability to, legally consider what I'm doing here. However, I will say in this case, I have read the briefing, and reviewed the statute, and I don't find a basis for withdrawal of plea or vacatur of my judgment. That would require finding of a fatal defect, as it were, in the plea proceeding. And essentially, the defect alleged here by Ms. Corbett is that, Judge, you're allowed to draw some inferences in the factual basis of your plea, but you went beyond drawing an inference. You went to rank speculation, as we would call it in the legal world, as to what Ms. Corbett knew, and further as to the sequencing or the economics of the business that she rendered, or that she operated on Plainfield Avenue in Grand Rapids, or Grand Rapids Township, as it were. And the statute at question here that Ms. Corbett entered a plea to was Michigan Compiled Law 750.457, which reads, any person who knowingly accepts, receives, levies, or appropriates any money or valuable thing without consideration from the proceeds of the earnings of any person engaged in prostitution, or any person knowing a person to be a prostitute, lives or derives support or maintenance in whole or in part from the earnings of the proceeds of the prostitution of a prostitute, is guilty of a felony. Now, and I agree with Ms. Dager that statute probably comes from an older time when the law contemplated, perhaps the classic pimp who's out there with a stable of women, and the woman is involved with prostitution. The pimp perhaps provides banking protection, but also appropriates a portion of the money she receives from prostitution acts. And that's not what happened here, though certainly, like the classical situation, Ms. Corbett did provide, the location, the surroundings, and I think that at least during a portion of her own allocution during the sentencing process, indicated that part of her basis for doing this was she had been involved with or observed another business that didn't provide what she viewed as adequate protection for the women that were involved here, and perhaps allowed the customers to pressure them or persuade them to perform additional sexual acts that she thought was unsafe and improper. And so she builds a different business model, as it were, that she believed provided more protection for the women involved. Now, and as I said during the sentencing, the law doesn't make any distinction between sexual acts, and we do have case law out there that says, of course, sexual acts include manual stimulation, as appears to be the primary sexual act we're talking about in Ms. Corbett's situation. It's a very broad definition, and I think that broad definition, of course, in performing what we call statutory interpretation, it's important to read the statute word for word, and I agree wholeheartedly with Ms. Dagger. Part of that is giving effect to each word of the statute, and then trying to discern what was the legislature's intent when they passed the statute, perhaps in an outdated time, or before we had stuff like the internet and instant messaging and stuff like that that changed every business model, not just a business model for prostitution. And in this case, the statutory language is actually quite broad because it says that any person, and it gives also a broad definition here of how that person receives a financial benefit. They accept, they receive, they levy. Levy, of course, I associate.
Wait, I thought that's what he was doing. Yeah, he's a long-winded talker. That's for sure.
With taxation. Of course, that's not what happens here, but nonetheless, there or appropriates, i.e., that would be the appropriates, the pimp going to the prostitute and saying, hey, you hand over the money to me. That's not what happened here. However, in a transactional sense, and I also look down here, the person takes without consideration, that is, they're not giving anything necessarily back of value to the individual who they get the money from the proceeds of the earnings of any person engaged in prostitution. Now, read in its absolutely most narrow sense, that could include a time factor, and that the person has to commit the act of prostitution and then hand the money over in that classic pimp model that I talked about earlier, which was not what happened here. Here, the timing sequence of these men patronizing this business is they come in, they pay the money to the house, the door fee for the room, for access. And let's be honest here, they're not renting a room, to use the computer in that room to do drafting and print out a 3D model or something. They're renting a room with a bed or massage table or something that they know contains a young woman who they believe, because of the way that they learned about this business, will provide a sexual act. And Miss Corbett did testify, she's aware of that. Was she aware of the exact act and the back and forth between the customers and the woman in the room? No, but she was aware that there was money exchanged in those rooms in return for sexual acts. And I think that taking the broader reading of this, that the earnings of the person engaged.
This just made me laugh out loud. Thank you so much for this. If she just, okay, Judge, fine. I'll stick with the sentence. This is taking way too long. While I'm paused real quick, Phil, thank you so much for the 5 gifted memberships. I do appreciate it. Welcome to the 5 new members. That's 10 from Phil tonight. Thank you, bud. I appreciate it.
In prostitution, well, after all, the reason that the men are coming to the business in the first place isn't to get that room for an hour, isn't to lie in the bed for an hour and talk to the woman. They are coming into, at least in some instances, and it doesn't have to be every instance. In fact, it probably only has to be one instance to fulfill the statute, in at least one instance, the person is coming in and engaging in an act of prostitution. And in my view, in light of the way the transaction occurs here and the use of the word proceeds in the statute, that there's a broader transactional view here, and that in terms of the customer coming in, they're going to pay $50 and they're going to give whatever they give to the woman inside the room, and the entirety of that is to facilitate or enable or make happen the act of prostitution that occurs. And I believe that is a reasonable inference for the court to make during the plea colloquy and during the acceptance of the factual basis for this conviction here. So I don't think, in other words, that there is a time sequence that the proceeds have to be given first to the prostitute and then the prostitute has to give some to Miss Corbett. I believe that the overall basis of the transaction, even though that's not clearly spelled out in the statute, is one that facilitates prostitution, and that the earnings that were paid to Miss Corbett, that is for the room, the access to the woman. And after all, she didn't just say, hey, I set up this business with 3 rooms in it, and there happened to be women that came in here and wanted to do massage and etc. services, but rather her testimony was she formed this business for the purpose of creating this environment where sexual act was provided in a way that she believed was safer for the women. So
Yeah, we just watched the court reporter videos. What was that, 2 weeks ago, when they were behind on releasing transcripts? Man, a Michigan court reporter can just say, "Oh, I'm sorry, I'm behind. I've been dedicated to Judge Rossi's courtroom for the past couple weeks," and everyone would understand. Like, oh yeah, yeah, take your time. Yeah, we get it.
I don't think that I over read or applied the statute overly broadly in this case. I think the statutory language can be read and should be read as encompassing this entirety of this transaction that involves, after all, at the end of the day, it is transactional. The customer comes in, they pay money, albeit to two different sources, one for the room, one for perhaps more money in the directly in the room, negotiated with the young, the woman in the room herself. But nonetheless, the overall transaction is one that facilitates a sexual act in return for money. And Ms. Corbett knew that that was occurring. So I don't think that that is an overly broad reading of the statute, nor do I think it supports the type of defect that would allow vacatur of the plea by me at this time. Thus, I'll allow the plea to stand and the motion is denied.
Thank you, Judge. Two things. I'd be glad to do the order and submit it to you for signature, the order for denial.
Very well.
And then I can serve that to the prosecutor if that's acceptable.
We presented just a general order. It's just a standard blank.
You want to do that? Okay.
The court already has it. Yep.
Oh, it is. Okay, good.
Yep.
Okay, so the order's taken care of. Number two, could I have a few minutes with Ms. Corbett in a breakout room, please, before we sign off?
Certainly.
Okay.
Oh man. Oh man. I don't have anything else to say. Nothing. There's nothing I can say. I mean, he just successfully summarized the entire Constitution. So we're just going to move on to the next case. All right, we're moving to Judge Carmi's courtroom. Now I say Judge Carmi. She is a judge now. She was a commissioner for a long time. She was the prosecutor in is it Battleground? Yeah, Battleground, Washington, in Judge Wheeler's court. She was a prosecutor there for a long time. That's where we got to know her. Then she started she was a commissioner on some landlord-tenant cases. Something happened over the last couple months because she's a judge now. So congratulations to Judge Carmi. Yeah, let's go.
Let me get back into presentations for today. We have the Garcia v. Garcia matter 25-327-408. And I do see Ms. McLean there, and I believe we now have Mr. Garcia. Sir, are you with us?
Yes, ma'am. Yes, Your Honor. Excuse me.
Okay. All right, Ms. McLean, I'll turn it over to you.
Your Honor, we're here on a discovery review. The court had ordered Mr. Garcia to produce specific items relative to our discussion the last time we were before Your Honor. At this juncture, I do not have documentation from OPM related to any potential outstanding balance of his.
There are no ghosts in there. That courtroom's empty. No, there's not, Jedi. There's absolutely no one in there. I don't know what you're seeing, but the courtroom's absolutely empty. Yep. You're the only one that sees that person. So they're definitely not there. No one's there. P.S. No one tell Jedi this is a joke. No one sees that person. Don't tell her. Make her believe that no one's there.
His first pension. So that would be question 7. On question 14, he did provide documentation on his TSP that suggests that was cashed out, I believe, in 2023. However, I don't know if there's any FGLI, which would be the federal life insurance that typically is afforded these folks. And so when I asked for benefit statements, that would include those as well. So I haven't received anything as to an FGLI for number 14. I asked at question number 32 about places that he'd applied for employment. We had that colloquy at the last hearing that he didn't keep those records. I still have no information as to any applications for employment from him. On number 38, I asked specifically about mental health medications, specifically as a result of medical treatment, psychological counseling, or other therapy. Have you been prescribed any psychoactive drugs? And it goes on to identify some of those. And I had specific questions A through G as it related to product name, prescription use, the date of initial prescription, the prescriber, the dates of refills, the frequency and duration of each product being taken, the dates of termination, if applicable, and the reasons for termination. Again, I disclosed at our last hearing that I've received medical records. He has not specifically answered those questions, and he's not updated that. As it relates to number 41, I asked for him to produce legible copies of all materials, results, and reports relating to tests, treatments, prescriptions, other services. As I indicated at this juncture, he's not actually provided a written answer other than to produce the medical records. On number 96, I had asked for him to provide statements related to the children's psychiatrists, psychologists, counselors. He did provide me a CPS report. And then we have previously, through my client, provided documentation of Xander's inpatient treatment down in California, but I haven't received any additional documentation from Mr. Garcia relative to that issue. On 101, this deals with the the home video cameras. If you recall, originally he claimed there were none. After our last hearing, I received 36 videos, which I assume have been cherry-picked by him. They range in date from June 20th of 25 to February 20 of 2026. So I do have those 36 videos. At 98, there was the request for the witnesses, including expert witnesses. He disclosed 10 witnesses. 2 appear to be experts, and those would be Eliza Yabali and Della Ramirez. They're both identified. Dr. Yabali is identified as primary care physician, and Della Ramirez is just identified as continued mental health provider. And then he lists 8 more individuals who are identified as either family or family friends. As it relates to the expert witnesses, I have no CVs. I have no opinion information. I have no records as it relates to their expected testimony. And you had that specific discussion with him about the requirement for him to produce appropriate requested documentation that was outlined in the discovery request as it relates to expert witnesses. So I don't have any of that information. As it relates to the 8 lay witnesses, he provides name, address, telephone number, relationship, but he does not produce any information as to the subject matter of their testimony, which again was a specific request of mine. So as it relates to exhibit 9 or question 98, that was specifically as it related to expert witnesses. He produced all of them as it related to that. Again, I've only identified 2 as experts. Request for production number 99 was asking for their opinions, CV, as relates to experts, the opinions, CVs, and all of that information. And again, I don't have any of that.
Yeah, Matt, I did not. I was more excited about telling you guys that, Miss Carmi is now a judge. It's Judge Carmi now. I didn't tell you what was going on here. Also, I remember this being a little bit more exciting. So hopefully he says something that makes this a little bit more exciting, because I hope I didn't strike out on this one. I may have, though.
Mr. Garcia, what do you want to tell me?
I've done the best I could, Your Honor. I was given a week to include having to move and rehome things. I did what I could.
Okay, Ms. McLean, what's your
Hopefully he says something interesting. Yeah, nope. I did the best I could. Oh man. Well. All right.
request today at this review? I see you guys are on docket, looks like on the 10th for different matters, but similar matters.
Right, ongoing issues.
Yeah.
So my request at this juncture is that the court enter a limiting instruction that discovery is limited to what he's produced as it relates to some of those missing items, particularly the FERS information that I think is going to be germane to the court's ultimate determination as it relates to property, and what I imagine I'll simply need to follow up with subpoenas to OPM and see what I can secure from them. So I would ask that the court enter a limiting order. I guess my main concern too, as it relates to witnesses, I mean, discovery's been outstanding since, I'm sorry, I didn't get that in my notes. I think since July.
August.
July of 2025.
Okay, so I mean, we're what, August, September, October.
All right. Well, so discovery is outstanding. You know, that's better than good. It's outstanding, right? No, that's not what she meant. I don't know what to say. I'm trying to make this a little bit more entertaining because I do think I struck out on this one.
For November, December, January, February, we're 8 months into this. The questions haven't changed. So, and we're trying to get this thing moved forward. Obviously, witnesses would be important for the guardian ad litem as well. So, I would ask that you strike his effort at expert witnesses and enter limiting instructions as it relates to the balance of this. I would also ask for the court's consideration on fees. This is, I don't know, the fourth or fifth time we've been in here as it relates to discovery stuff. And it's just concerning.
Okay. Do we, and we don't have a trial date yet, correct?
No.
Okay.
We're waiting, the guardian ad litem final report, I think, is due sometime in May.
Okay, understood. Okay, a couple things. As far as the ongoing, everything but witnesses, I will enter a limiting instruction. Essentially, Mr. Garcia's testimony will be limited solely to those facts and data that he has supplied to date. And so, you know, the basis for my ruling is we're 8 months into discovery or thereabouts, and seems like we're kind of at a standstill, and Mr. Garcia is telling me that this is what he has. And so I'm going to take him at face value that this is the evidence he will present. I am going to allow some small latitude for further filings on witnesses, only because trial has not been set. So I don't think there will be prejudice to the other party, but it is going to be a short amount of time. So Mr. Garcia, rather than me striking your witnesses today, I am making a finding that you haven't complied with, I believe, 98 and 99, which are the requests for CVs, a summary of their expected testimony. You do need to respond to those. I understand you're doing this unrepresented, but you're held to the same standard and burdens that an attorney is held to when you do a case on your own. So I'm giving you the same latitude I would likely give an attorney in a case.
Hey, Gino's baby. Welcome. Glad to have you here. Hopefully you're enjoying the show. I mean, it's been an interesting night, so hopefully you're enjoying the chat. That seems way more on point for tonight. But thank you for joining us.
Where a trial is not set, I will give you just a couple of weeks to get that done. Do you think you can have that done in 2 weeks?
I do not.
Why not?
I'm currently moving back and forth, getting my personal property from Washington State to Colorado, and I'm still dealing with residence issues. As you see, Miss McLean keeps bringing up more motions on top of more motions.
Well, sure, but don't you've identified witnesses.
Right, but they're also federal employees, Your Honor. That's a lot harder for me to get information out of than just Joe Smo doctor and the
Hold
economy.
on, you've identified them as witnesses. So I assume you know why you're planning to call them and what you expect them to say.
Yes, Your Honor.
That's what you have to provide. For the expert witnesses, the other side is entitled to a resume or curriculum vitae, essentially. So how much time do you think you need to get those things done?
1 second, Your Honor. If I may.
Okay, yep.
If possible, April 1st, Your Honor.
And the court's aware that I'm out the entire month of April, so.
Yeah. And the guardian ad litem needs to get reports done by May. So what I am going to do, sir, this has been going on for 8 months. I'm going to give you, I said 2 weeks, I'll give you 3 weeks. We'll put this back on for review March 27th. And I wanted those 98 and 99 as far as expert and lay witness testimony and any background biographical information about them needs to be given to the other side, okay?
Yes, Your Honor.
I am going to award attorney fees for this hearing. I do think that that's the only way that we're making progress in this case. Ms. McLean, I don't know if you have that information or if you want me to.
Wait, did she ask for attorney's fees? I missed that. I think that was part of the time I fell asleep. I've been sleepy since Judge Rossi, so I didn't hear her ask for attorney's fees. But no, he had a week to turn over, and he did the best he could. I did the best I could, Your Honor. I mean, I know he failed the order, but I almost just voted. I know how much she gives him. I'm remembering this case now.
If you want to supply a time billing for preparing for today's hearing and attending today's hearing, and Judge Scudder can deal with it on the 10th. It's up to you.
Well, I think you're better suited to make the determination as it relates to fees, since you're the one that's been reviewing this. I would expect or anticipate that I probably have 3 hours into downloading and reviewing.
Oh my gosh, none of your business. I am so sorry. How did I miss that? I don't know. I can't even blame it on the chat because StreamYard actually fixed the frozen chat. It hasn't frozen in a couple weeks. None of your business. Thank you so much, and I'm sorry. You can't pay to get your time back, Judge Rossi, from Judge Rossi's ruling. Paying for anything else should.
What documentation and videos he has provided. And then I probably have 30 minutes in prep for today.
Okay.
And then our hearing today. So figure 4 hours. I'm at, I don't know what, I think I'm at $4.50 an hour. I don't know. I don't remember. Let me look. That's above my pay grade.
Yeah, I hear you.
I heard the beep in my headphones that, my Bluetooth has been randomly kicking me out for just, it kicks you out, then brings me right back in. But I don't know why it's been doing that lately. All right, let me start over. None of your business. Thank you for the super chat. I apologize that I missed it. You can't pay to get your time back from Judge Rossi's ruling. Paying for anything else should be done with your Cheshire card. Thank you. None of your business.
My assistant is saying yes.
Okay. All right. So I'm not good with math. That would be 1,800. I do believe that's reasonable. I'm going to add on $200 as a sanction for having to do this repeatedly. Sir, again, I'm just going to remind you, so it'll be a total of $2,000 in attorney fees and sanctions for discovery violations that we have to keep addressing. Sir, I just am going to remind you, I understand you got a lot going on. I hear you when you say that. but I can't treat you any differently than a person who has an attorney handling this matter for them. So I have given you a final deadline. This truly is last chance. So please get that information in, or the court essentially will have no choice but to potentially exclude those witnesses if the other side isn't made aware of what their potential testimony will be. Okay.
Your Honor, are you opposed to doing presentation of the order from today's hearing also on the 27th and then making the judgment for the fees and sanctions effective today's date?
I think that makes sense. And so we'll do that. We'll set it to presentation and review to March 27th at 8:45 via Zoom only. But the $2,000 judgment is effective today.
Okay, I'll get that order out this next week to Mr. Garcia.
Okay.
Thank you.
Yep. Any clarifying questions from either party today?
No, thank you.
No, Your Honor.
Okay. All right. Thank you. But
Come on, Judge. Charging him $2,000 when he was given a week for discovery. That seems a little much. Hold it in advance. Like you're gonna owe $2,000 if you don't get her the rest of the discovery in a week. That seems a little harsh. I don't know the case though. Maybe she did say it's been going on for 8 months. Yeah, the discovery order has been outstanding for a long time. That the joke I made earlier. So yeah, maybe. Okay. I'm not going to criticize Judge Carmi. I played this because I was excited for Judge Carmi. I just I was excited for it. All right. We still don't know who you're talking about, Jedi. There's no one in the courtroom. There's absolutely no one in the courtroom. So I don't know what you're talking about. Okay. I am going to actually double check all the super chats. I don't want to accidentally miss another one. Okay. Nothing's missing. But that's it for the show tonight, guys. That's it. Thank you so much for joining me this evening. I do appreciate it. Thank you for all the very generous gifted memberships. You guys were awesome tonight. Members Monday tomorrow night. Let's see those new members and members Monday. We have a lot of fun. I open up the panel, allow anyone who wants to come up. Any member can come up on panel, and we just talk for a long time. We turn a 45-minute video into a 2-hour live stream just about every Monday. It's fun. So hopefully we'll see you there. Other than that, thank you for the super chats, membership milestones, mods. As always, thank you so much for your hard work. That's all I got. There's usually not someone to raid on a Sunday night, but I will double check right now. Where could we possibly go? Oh, Credence and Mikey's on. Yeah. All right, we'll go to Credence and Mikey. They are probably going to finish right when I send you over. Every time I raid them, that's what happens. So if that does happen, I apologize. But jump over there quickly and tell them that I sent you. But you guys are awesome. I'll see you all. I'll see the members tomorrow night. Everyone else, I'll see you Tuesday night. Okay, bye.
Both, and we'll go ahead and end docket with that.